Hello, this is Andrew Schiestel from TBK Creative. TBK Creative is a company that works with medium-sized organizations, helping them solve complex web design and digital marketing challenges, allowing them to grow their brand value and revenues as a result. Back on July 22nd, 2014, I got a chance to sit down with one of Canada's foremost legal authorities on the Canadian anti-spam law, business and IT lawyer David Canton from Harrison Pensa. In a few minutes, we're going to hop over to the conversation that David and I had. If you're a marketer or CEO of a Canadian company, you're going to want to listen to this call if you're looking for ways to have your company comply with CASL. You're also going to want to listen to this call if you're looking for tactical tips to mitigate your risk from penalties, fines, civil litigation, and director officer liability. You're also going to want to listen to this call if you're looking to meet CASL, but you want your organization to maximize its marketing performance while meeting those rules. Here's some things you're going to learn. You'll understand better under what circumstances you or colleagues can send out commercial electronic messages, short for CEMs. You'll better understand what this 3-year transitional provision is all about, and you'll know who must be purged from your list immediately and who can stay. You'll learn about some exemptions most organizations don't know about right now that make it unnecessary to have an unsubscribe mechanism from some of your CEMs. David and I also discuss 3 different types of unsubscribe mechanisms with tips on what you should use for best results. We also discuss 5 items that must legally be on your subpages with forms if you wish to gain express consent from people filling out those forms. David and I talk about a whole lot on this call. This is a talk not laced with legal jargon, but one jam-packed with marketing scenarios that you're going to be able to relate to as a marketer, executive, or CEO. So without further ado, let's get on with the call. So David, welcome to the call.
Thanks, Andrew. Glad to be here.
All right. So David, you and I have been bantering back and forth for weeks now about CASL with and really looking at kind of the marketing scenarios of it, because I think what a lot of us struggle with as marketers and executives is when you kind of go through the legislation, there's a lot of parts of it that's just kind of challenging from a practical perspective. So we're going to dive into those kind of different scenarios. But maybe to begin, can you tackle this from maybe a 30,000-foot view and just explain better for everybody what the Canadian anti-spam law is and why it exists?
Sure. Up until this was passed in July, or came into force in July, Canada was one of the few countries, few countries that did not have some sort of an anti-spam law. And most of the laws of the other countries on anti-spam were basically unsubscribed things. So you could send what you wanted, but if you didn't, if someone asked you to stop and you didn't, then it was a problem. So Canada decided that they would implement the strongest anti-spam legislation in the world, and it did that. Now, unfortunately, this act is badly drafted. It's ill-conceived in its approach. It defines spam far too broadly because most of the people on this call shouldn't have to deal with this. But the reality is it's here, and kind of we have to deal with it in all its subtleties.
So a big part of the legislation is what has to do with a commercial electronic message, short for CEM. So can you maybe break that down for everyone?
Yeah, the key of the act is that it deals with what they describe as commercial electronic messages, or CEMs. And in essence, I'm going to paraphrase the definition here, but it's an electronic message that, having regard to the content of the message, the hyperlinks in the message, or the contact information contained in the message, would be reasonable to conclude has one of its purposes to encourage participation in a commercial activity. Now it goes on and on from there, but basically any email that you're offering to sell something or sell your own services or promote somebody as selling a product is caught. So fundamentally, it's any email that's promotional in nature. And another thing to keep in mind, and we'll dive into this a little bit later, but it's commercial electronic message is defined as broader than email.
Okay, so if you're on the call right now You probably work within an organization that at some point sends out a commercial electronic message. I don't know if there's an organization in Canada that wouldn't at some point send out a commercial electronic message. And so what Castle's really governing here is a big aspect of it is when you can send out those CEMs and how can you send out those CEMs. So David, can we go there then? Can you maybe define for everybody what requirements need to be in place for somebody to even send out a commercial electronic message?
Sure. I think the easiest way to look at the Act is that it defines commercial electronic message obviously very broadly. That's their definition of spam. And then it has a myriad of exceptions along the way, which doesn't make it easy to follow. But there are, in essence, three different outcomes you can do. If it's not a CEM, or if it meets some of the exceptions, then you can send it, you don't have to worry about the Act. If it is a CEM, and you can somehow fit it into one of the express or implied consent rules that are in there, then you can send it, but you have to send certain information along with it. And if it's a CEM but you can't shoehorn it into one of the exceptions, you just can't send it at all.
What are some exceptions?
Okay, there's a lot of exceptions. The ones that would be most valuable to most businesses. Mm-hmm. There is a overall sort of business-to-business exception in the regulations, so that if your company has a relationship, and they don't define what relationship is, but if your company has a relationship with another company, the employees of those two companies can send emails back and forth without having to worry about the formalities of the Act. So basically what it's intended to do is if you've got an ongoing email exchange with a customer, for example, if that customer is a business customer. Mm-hmm. So that's one of the most, the best ones. There's also another exception is a personal relationship one, so that, and this works on the individual level, not on the corporate level, but if the person who's sending the email has a personal relationship, and it takes about half a page to define that, but basically if you have a personal relationship with the recipient, then you can send that without worrying about the formalities of the Act.
Right, right. So I'll throw out a couple scenarios then, David, and let me know if these would meet exceptions under the legislation, because I think these will probably be some kind of real situations that people listening are kind of in right now. Manufacturer, so that produces a product and they have a dealer network, and so those dealers are independent companies, and obviously they need to be sending communication of some form back and forth to function as a business. Would that fall under an exception?
Yes, one of the exceptions that well, first, let me back up for a minute and say you can always get express consent. That's the gold standard. So going forward, the best is to always get consent. Mm-hmm. Sorry, my screen just went up on. Okay. It's always best to get express consent. And going forward, if you can get yourself in a process where you routinely try and get express consent from your customers when they come sign on with you, that's a great thing to do. But absent that, there are some implied consents in there. And the most important one for a business is that if you've done business with that customer within the last 2 years, you have implied consent to send them a commercial electronic message. Now, keep in mind that any of this stuff, whether it's express consent or implied consent, the recipient can always unsubscribe and say, don't send me this stuff anymore, and you have to abide by that. But absent that, this implied consent works for existing customers or ones that you've done work with in the past 2 years.
Okay, so I use the manufacturer to the dealer relationship, and in that case, what David's pointing out is that would be a supplier to a customer relationship because the manufacturer is selling products to a independent company that's then reselling it, but it is a customer of the manufacturer, and therefore you do have implied consent in that situation if they have bought products from you in the past 2 years, and we'll get to the timeline stuff a little bit more later in the call. But in that case, you have implied consent to be able to send them communication. But you do need, in that case, David, you do need to have an unsubscribe mechanism.
Yes, and that situation is a bit. Sometimes there's a couple of places you could shoehorn things in. That relationship might work under the exception where you have the relationship between the two corporations as well.
Okay.
And where it gets tricky is if you've got that business-to-business relationship, you don't need to worry about the formalities. If you're relying on, if it's a CEM and you have to rely on the implied consent thing, you do have to pay attention to the formalities. And the formalities of that, if you can send a CEM, is that you have to disclose some things. So you have to disclose your mailing address or your snail mail address. You have to disclose at least one of your website address, your email address, or your phone number. So you have to disclose all that, and your corporate name. And if you're carrying on business in a name other than your corporate name, you have to disclose that. And you also have to put an unsubscribe mechanism in there. So what you want to do is you want to link to say if you want to unsubscribe, click here. So you have to do all of that. Now, businesses are taking different viewpoints on that. Some businesses that say, you know what, the bulk of our emails aren't CEM, are relying on those when you send CEMs to add that stuff in there. Some businesses are saying, you know what, we send enough stuff that is CEM that we're just going to mandate that there's a footer on everybody's email all the time that make sure it has the disclosure information and the unsubscribe just to be safe.
Okay, and I'm going to have some questions in a bit as well regarding the unsubscribe mechanisms. What kind of is allowable there? Because there are some different ways that you can do it. I just want to go back to something you said, David. So you said that you may be able to shoehorn a certain business-to-business relationship under a different exception where it's not really implied consent as a past customer, like an existing business, past customer, but that you're shoehorning it under instead more of a business-to-business ongoing relationship. What section? Do you have that handy? What section of the Act, or if that's the regulations?
It's actually in the second set of regulations, the Industry Canada regulations that came out in December. And what it says is basically that it's under the title Excluded Commercial Electronic Messages. It's Section 3 of the regulation. But it says that Section 6 of the Act, which is the operative section that talks about having to have consent and what you have to have in it, doesn't apply to a commercial electronic message, I'm going to paraphrase here, but sent by an employee of an organization to an employee of another organization if the organizations have a relationship and the message concerns the activities of the organization to which the message is sent. So, so first of all, if you're sending email that isn't promotional in nature, if you're sending email that just, isn't promotional, it's transactional, then the Act doesn't apply. But even if it is a commercial electronic message and the businesses have some kind of a relationship, but again, that isn't defined, but it would be some kind of ongoing business relationship, then you don't have to get, or then you can take advantage of that exception.
Okay, so to summarize that a little bit, if it's a past customer, there's a good and you're sending them a CEM, there's a good chance that it's going to fall under implied consent, where you're given two, and we'll break down the dates more, but 2 years from the date of last transaction. You have to follow some of the other criteria such as including your company name in the CEM, mailing address, and email or web address, or what was the third one?
Phone number.
Phone number, okay?
Right.
And then so there's that, if it's kind of falling under that vein, or that relationship could be falling under Section 3, under a set of regulations that was released by Industry Canada, that if you have a kind of an ongoing, I'm paraphrasing a little bit, an ongoing business relationship between your company and another one, then you have an exemption. In that case, David, if it's you did say that if a message is transactional, it's not a CEM. So if you're versus promotional, so if you're in that second vein there, you have that ongoing business relationship. Let's use an example. Let's use the example of a law firm and an accounting firm working on a client file, because that's a very common, right? You know, your company and another accounting firm. And let's just say it's transactional. There's some kind of transactional type of message. Does David, who's sending out that message to the accounting firm, does he in that case need to include things like an unsubscribe function? You know, basic information on your company at the bottom, because it's not. Yeah, I'm on that second vein there.
Yeah, in that situation, no, because what I'm doing is I'm sending an email to the accounting firm saying, okay, you know, what should we do? What share provisions would you like to see in Company X's new corporation, for example? And that's purely transactional. It doesn't fall into this at all. But if Harrison Pensa has a relationship with that an accounting firm, right, a business to relationship, which basically I would say if you do enough work together that you can claim that, then I can even send them a message that says, hey, I'm now doing X legal services. Do you know of any of your clients who might want to use that, which is clearly a CEM.
Right.
But because we have this business-to-business relationship, that I don't need to do the formalities. But if I was going to send that to anybody else, it's definitely a CEM that requires, at the very least, all these disclosures. And depending on who I send it to, I may not be able to send it at all without violating the Act.
Okay. So that's if you're listening on the call, that's a really important item, I think, for a lot of you. So you'll have to start to define then, if you have these kind of ongoing, really good relationship, business-to-business relationships with certain companies, you may not be falling under Section 6 of the legislation. You may have an exemption when sending CEMs, and you always have an exemption when not sending a CEM. And then if that's not the case, you may have to rely on, if you don't have express consent, you may have to rely on implied consent. Did they purchase a product in the past? David, can you break down? Let's talk implied consent for a minute. So let's go back now to just implied consent, because I think a lot of people on the call will be in that situation. There are two popular ones that I know private sector businesses deal with. One is when somebody has previously purchased a product from that company, and the other one is when somebody has previously inquired about the company's goods and services. Can you explain those two a little bit more, and then what timelines are associated with that implied consent? Right.
Now, keep in mind that you can always, if someone sends you an email to ask you something, you can always reply. So if someone that you've never heard of emails you and asks you about your product, you can certainly reply to that because they've asked for it. The consent, there's a section that talks about implied consent. For if the person who sends it has what's called an existing business relationship with the person to whom it is sent. And the existing business relationship, again, has a long definition. All these definitions are long and complicated. But in essence, it's that if it arises from the purchase of a product or a service within the last 2 years, Another one is the acceptance by the person to whom it was sent within 2 years of a business, investment, or gaming opportunity. Not sure what that means, but that's there. Bartering of those things, or if you've entered into a written contract regarding any of those things, the 2 years run. Now, there's a separate one that says you have 6 months worth of implied if someone has made an inquiry or an application within the last 6 months. So if someone makes an inquiry about your product, you have an implied consent for 6 months to send them promotional material.
Okay.
So that's the existing business relationship portion of implied consent.
All right. So somebody has previously bought a product from you. If it's within, and I'm going to get to the transitional provision in a moment. I think we're going to create a segue for that. But for the purpose of this segment, someone that has previously bought a product from you, 2 years, implied consent. You can send them CEMs for up to 2 years from the date of last transaction. And if somebody has inquired about your goods and services, it's rather an or if somebody has inquired about your goods and services but did not provide express consent, did not purchase your product, has not unsubscribed, you can say you can send them a CEM for 6 months.
Yes.
Or CEMs, multiple CEMs.
Multiple, yeah.
Unless they unsubscribe, because you still have, right? So as you're sending these, right, David, you still then need, I'm going to go back to your earlier comment, you still need that basic contact information and unsubscribe mechanism.
Yes. If you're falling under the implied consent tests, yes, you have to have those formalities in the email.
Okay. And just so I have it flat, if you're falling under that other regulation, Section 3, that we talked about,
yes,
where you have the kind of better, if you want to call it that, the better, deeper relationship with that business,
right,
you don't need your contact information or an unsubscribe function.
That's correct.
Okay, I like that a lot. That's really important.
And there's no time limit on it either.
Okay. And there's no time limit. Really good.
No express time limit.
Okay. On Section 66 of CASL, transitional provision.
Yes.
Allowing for 3 years of CEMs or sending CEMs to a certain type of person. Can you speak about the transitional provision more?
Yeah, the transition provision is can be a bit confusing. So what it does, it gives 3 years that you have. You can send CEMs in limited circumstances. So the first thing is that read the existing business relationship without reference to a time frame, without reference to the 2 years or the 6 months. So in other words, if you've ever done business with somebody, ever, in the history of your company, then that's the first test. It's not a 2-year limitation. The second one is that you must have, before July 1st, sent that person a CEM before. In other words, sent them some kind of a promotional email before July 1st. So if you can fit those two tests, so if you can find that they have an existing business relationship without reference to how long ago it was, and if you've sent promotional messages to them before July 1 of this year, then basically it deems you to have implied consent for 3 years from July 1. Okay. So that idea is to transition people in so you have time to get express consents, but it's very limited in its application because you have those two very important things that you have to have in place for it to work. So all the businesses that were sending out the express consent emails in, yes, from kind of like June 15 on, if you will, last minute, who right now are purging their list if somebody did not hit express consent,
a portion of the people they're purging may have purchased a product previously or inquired about their goods and services previously. They may be purging. Some businesses are going to be purging these people, and based on the transitional provision, they don't have to purge that.
Yeah, it's possible that some people are in fact going a little overbroad than they have to.
Yeah.
But you really have to look at it and say, okay, were they actually a customer, and did I actually send them a promotional email at some point in the past? But yeah, you can, if you did that, yeah, don't be in a too big of a rush to automatically yank those people off your list that didn't give express consent without at least thinking that issue through.
They just needed to join this call.
Yeah.
And so 2 more things on this transitional provision. It's, to be clear, David, it's not just past customers, but it could also be somebody that previously inquired
yes,
about
that's correct.
an organization's goods and services as well.
Yes, that's right.
Yeah, what David's pointing to here, guys, in section 66, it points to another section that pertained to the last section of the talk David and I just had about if somebody has bought a product or if somebody has inquired about your goods and services. So that's fine too if somebody maybe didn't buy a product and service from you, right, David?
That's right. Yeah. That's one of the challenges of this act is it's anybody who's familiar with software design, it's designed like spaghetti code where everything points someplace else. It's really difficult to follow.
The other question I had about the transitional provision, to be clear then, you said that the other criteria, so what you're looking for here, everybody, is, A, is this a past customer? Is it a past lead, if you will? Okay, that's fine, check mark. Second piece that has to be in place is, did I send them a CEM? David, right. If you never got a response from that person, if you never got a response from a CEM that you sent them, is that still okay?
It's not supposed to matter whether you got a response. All that matters is if you sent that person a promotional email. So if for example that you had a mail list and you were sending out a quarterly newsletter that was promotional or something like that, and keep in mind it doesn't take much to cross the promotional threshold, then you may very well have those people grandfathered in under the transition period, at least for the 3-year period.
Mm-hmm, mm-hmm. So then everybody, when now you can kind of look at your list, and it's a very valuable information David's sharing, because you can look at your list and now say, okay, this person can either stay or the person has to go. This person can stay, the person needs to go. And you have that 3 years, and you have 3 years to either have them become a customer, which restarts the clock under the 2 years from last transaction. Right. Build a personal relationship or a kind of that deeper ongoing relationship, or have them provide express consent.
Right. Yeah. And what you're going to see is that 3 years from now, or just under 3 years from now, you may very well see the same deluge of email that we had last month from people saying, okay, the transition period's up. I'm really mean it this time. If you don't consent, you're not going to get this anymore.
Yeah, the best thing is to say we need to remove you on the list in June. Unless you click this button, and then you keep them on the list after July. Yeah. I hope that's not happening, but it probably is. Okay, I want to circle back to something that's really important, and it's probably on a lot of people's minds on the call: the unsubscribe mechanism. So, what I find interesting and scary when you first look at CASL when it comes to unsubscribe mechanisms is you need it not only in kind of this bulk email fashion, which I think a lot of us marketers are used to when you're sending out an email campaign using a third-party software, but that the legislation also applies to a one-on-one email. So if you are an accountant sending a CEM to a past customer, you now need an unsubscribe mechanism. So now on that CEM. So David, I want to understand better what the regulators say about what is a sufficient unsubscribe mechanism. I'm gonna share 3 that I think are popular amongst marketers, and maybe if you could just provide commentary.
Sure.
On the three. So if we're sending an email to someone, and this one we'll see more popular within a third-party email software such as a MailChimp or a Campaign Monitor or Constant Contact, and and we're all probably very familiar with it. It's when you scroll to the bottom and it says, "Do you wish to unsubscribe?" The user only has to click a button and something automatic happens. It purges them from the list. Right. So that's the first scenario. And for intents and purposes, we'll call that like automated. It's an automated unsubscribe mechanism. The second one, which a lot of us are familiar with too, is when you put this little line of text on the bottom of your email. It's kind of like the unsophisticated way, the quick way, and it says, if you want to be removed from future correspondence with me or my company, send a reply to this email, and in the title, write unsubscribe. So we'll call that manual. So you have automatic, you have manual. The third way, which as a digital marketer, I think has a lot of merit from a service perspective, really making sure you're sending the right message to somebody. But also, I think you'll see that it decreases unsubscription rates, is a managed subscription page. And this is where somebody clicks that unsubscribe. Maybe it doesn't say unsubscribe, but it says something like, manage your subscription, or maybe it certainly can say unsubscribe. They click it. It takes them to takes them to a subpage in a browser, and then it lets them either stay on certain email lists or remove themselves from certain email lists from that company. So we'll call that a managed subscription page.
Right.
So can you speak about those three scenarios, David?
Right. Well, the Act doesn't say a lot other than it has to be readily performed is the term they use. Okay. So your unsubscribe has to be readily performed. There's a bit of controversy over how far or what the extent of that is. And a lot of these different things are being driven by practicality. The first scenario where you just click on the footer and it says unsubscribe, it's automatically done. I mean, that's clearly fine. One of the reasons that you see sometimes when you click that once, you have to go through and to someplace else and say, are you sure you really want to do this? Or send you an email or that sort of thing. It's just so the person can make sure that it actually is the person who got the email that's doing it, because it would be easy to forward it to somebody else, or somebody else could unsubscribe. And
great point. Yeah, great point.
So you have to be really careful that you're not setting yourself up for people to subscribe and unsubscribe who aren't really who they say they are. And that sort of becomes in addition to a practical issue, that can become a privacy issue. The second scenario where you send an email back to someone and say, unsubscribe or whatever, or just respond or reply to this email and say unsubscribe. I mean, that's fine. That's readily performed, so there's no problem there. The other one, I think the third one is okay. There have been a couple of commenters who have said that they don't think that you can be forced to log on to a site to unsubscribe, but I'm not convinced that that's right. Because if someone's already signed up to someone and for something that they have to log on to get to, it just makes sense that having them to log on to unsubscribe or get off of it is not a big deal. And in my personal view, I could be stand corrected by the CRTC at some point, but my personal view is that that should be okay. And after all, I mean, you do want to make sure that you're dealing with the right person. And in fact, some people that have pages set up on their websites for people can go in and subscribe and unsubscribe, that's open to abuse because anybody can go on and kind of pretend there's somebody else. So that's why they sort of send the email and then respond to it to make sure. Some are people are taking different approaches to how you're unsubscribing. I mean, the simplest approach for most businesses is like one of the things when people do subscribe, you have to express to them what they're consenting to, and most people define that fairly broadly. That by entering my email address or by clicking the button, whatever it is, I'm consenting to receiving information about your products and services and promotional offers and whatever, however you want to describe that. But some businesses, and most businesses are just saying you're either in or you're out. There's no, you're in for some, or right. So you're either in for all CEMs or out for all CEMs. So that still means even if someone unsubscribes from that, there's still a few things you can send them that aren't CEMs. Oh yeah. So what you need to do, I lost my train of thought here.
That's okay. Can I ask you a question?
Yeah.
Okay. Actually, I'm gonna get to a question, but I want to make a statement from my opinion, marketing wise, about managed subscription pages, because you said something that I hadn't quite heard in that way before, and I really liked it. And it's very practical because I've seen it. It's when somebody clicks on subscribe. If you actually don't have a managed subscription page, that could be anybody, and that may sound like, well, that's not really practical because we're talking about somebody's email. But when we send out an email campaign, and a lot of email campaign softwares have this, it actually shows you the number of people that number of people that have opened up. Actually, let me say that a different way. It shows you the number of times an email is opened up. I don't know about people. I mean, you might have to get into IP addresses and stuff, but it shows you the number of times an email has been opened up from one recipient. And when we send out emails from TBK Creative, and if you at some point, if you're listening to this call, look at your own data, you'll notice there's sometimes one person's email opening it up 5, 10, 12 times. And so what we've sort of ascertained from that is that it's not the same person opening up their the same email 5 or 10 times from a company, because it actually happens a lot on an email blast. You'd be surprised. What we believe is happening is somebody's liking the content, and then they're clicking forward, and they're forwarding it to other people in their company. And it actually makes sense, because if you, let's say, received an email about Castle, and you have a whole department of marketers at your company really dealing with Castle right now, you may forward that one email to them, and that person has a person who might have received your forwarded email that you provided express consent for could unsubscribe from CEMs from that company.
Yeah, that's quite true. And to finish up what I was when I lost my train of thought there, what I was going to say was the managed subscription thing, where you have a person goes to a site and gives them an opportunity to pick, okay, I want this, I don't want this, I want this, I want this. That's perfectly valid too. Most companies don't want to get that granular, but if you're in certain businesses, you may find that's useful. The downside is that people might go to that page and go, oh, this is too much problem, too much of a hassle, and they just won't subscribe to anything.
Mm-hmm, mm-hmm.
But some people are using that approach.
If you received an unsubscribe under Castle, so you get an unsubscribe from someone, you can still send them an email if it's not a CEM, correct?
That's right.
Okay.
Yeah. Now, depending on what it is, you might choose not to, but yes, yep. Technically it only stops you from sending CEMs. And there's also a list of things that, well, the statute is kind of weird, because in one side of its mouth it calls them CEMs, another side it says they're not. But you can also send out, even if someone's unsubscribed, you do not need consent to provide something that's warranty information, product recall information, safety or security information, and things like that. So you're not scuppered from sending out the email that says, oops, there's a recall on the product you bought or something like that.
So if somebody, and that's a really good one, and David knows this. We had a client a manufacturer run into that very scenario a
Yeah,
few weeks ago. I was just wondering, can I actually send my list warranty information? So
right.
just to be clear about that, David, if somebody, manufacturer co. Has someone on their list who is unsubscribed from their CEMs, let's say through a MailChimp campaign, so they've sent them an email campaign and they've unsubscribed, that company can still send them information regarding some of those areas that you just said there, such as warranty information.
Yes, that's correct. Yeah.
Okay. What section of the Act or which regulation is that?
That's actually in the Act. It's under Section 6 of the Act.
Okay.
6.6 is the actual section. The bizarre thing is, just as an aside for how the Act is drafted and drafted badly, it says that you can send those things. You don't require consent to send those but you still have to have an unsubscribe mechanism in it. But what you're unsubscribing to, nobody can figure out because you don't need consent to send it. So it's really quite bizarre.
Mm-hmm. Mm-hmm.
Apparently the drafters of the legislation realize this, but it's too late for them to do anything about it.
Okay. You had mentioned, so a litmus test, if you will, everybody, that David had mentioned when setting up your unsubscribe mechanism and choosing if you're going to do the auto way, the manual way, or the managed subscription way. David said something, 2 words. You need to test if it is readily, if the unsubscribe is readily performed.
That's right.
What section of the Act, David? I like noting this stuff.
You know what? Off the top of my head, I don't remember what section that is. I would have to look for that.
Okay. Okay. Don't worry about that right now. Maybe we can get that later. Okay.
And it gets tough because there's when you add the Act and the regulations together, it's 44 pages long. So.
Yeah. I got one more item here that I want to kind of chew on with the unsubscribe mechanism. Okay, you have a company, and one of your colleagues, let's call it a professional services firm, because I think that's a real instance where you have different professionals who might have different. They may be responsible for certain vertical services for the same person or organization, such as an accounting firm, for instance. One accountant receives an unsubscribe. So the person, he or she really was sending a CEM and had an unsubscribe function. Let's say they got to that point, and let's call her name. Let's call her Andrea, and Andrea, the accountant, gets an unsubscribe. Michael, who is also the accountant for this person. Let's look at that scenario. What has occurred there? Has that person, the client, unsubscribed only to Andrea's CEMs, or by default has that client unsubscribed from the entire companies, which includes Michael's and Andrea's emails and others who are part of the organization?
I think the best answer to that is they have unsubscribed from emails from the entire organization, which shows one of the, like you've said before, when you centralize stuff and you're doing bulk emails and stuff where you've got 1 or 2 people that are responsible for it, these rules are bad enough, but at least you can understand them and corral them and put the practical stuff in place to manage it. It's the one-off emails that are difficult to manage because you have that exact scenario. So if you have, in that situation, if someone unsubscribes, you're not unsubscribing from the individual, you're unsubscribing from their business. So to take another example another way, if you have a sales force, right. Your sales force shouldn't be going. You shouldn't have 2 people in your sales force going after the same party anyway. But you could have a situation where that happens. If someone unsubscribes from salesman A, and salesperson B then tries to contact that same person, then you violated the Act. So you have to somehow track all this stuff.
Mm-hmm. I am very bullish on managed subscription pages, even more so as a result of this conversation we just had. And I'm bullish for three reasons. Yes, I think you'll notice the unsubscription rates would naturally be less if you go and do that, but that I don't think that should be the only reason you create that as a mechanism. I think the other two reasons are very important. I think the second reason is you get better service for that person. You ensure that they're actually subscribing and unsubscribing to what they actually want to be subscribed to and unsubscribed to. And I'll give you an instance where this happened. We actually had someone inquire about our services. We have implied consent to send them CEMs. We have a process within our company to add them to our email marketing list. And that person then unsubscribed to our email marketing list, but continued with communication back again, and then eventually downloaded one of our e-guides, which creates express consent. But you're in this situation where we're not actually sure what she wants to be subscribed to or unsubscribed to. So I think in that scenario, having a managed subscription page, that's why I call it service. You're actually providing them better service. Like you're saying, if you don't want to receive our email blasts, simply just say, I don't want to get your email blasts. But if you still want to get information about this or information on one-on-one emails about that from, let's say, Andrew or Melissa or somebody, then click these buttons. I think that's a better scenario for not only the business but the person. And then the third benefit I think with managed subscription pages is what you said, David, is making sure the right person actually unsubscribes to your correspondence.
Yeah, there's certainly a lot of merit to doing that. The one thing you have to be careful of is that you have to make sure that you can set up that managed page and you can find great ways to have get people to that and get them to sign up and all that kind of stuff. But you have to make sure that you've got somehow you set up so that your people are actually following that and not sending and recognizing that, I can't send this to person A, but I can send it to person B. So you have to make sure that that's coupled with a process to manage it, or you can just be, and if you can't manage it, you shouldn't be getting that granular in the first place because you're setting yourself up for failure into the act.
Yeah, great point. There is going to need to be, in Canada here, processes that probably have never been built before to manage some of this stuff. And I think it'll be neat to see some of the innovations that happen as a result, and some of the economics that will get created as a result of this as well, on the positive side.
I actually have a client who's developing a solution meant to handle that one-off problem right now. He's not quite ready to announce it, but probably will in the next couple of weeks, yes.
Yeah, okay. So much to talk about here. This is great, and I hope this call is really valuable for people so far. Let's talk, and we can't wait to get to your questions as well. I know they're pouring in here. Let's talk about a subpage with a form, because when you're talking about wanting to get implied consent or express consent, we live really in a digital age nowadays. With any business, you have a website, and it is a spot where that type of consent can get performed a lot. So if you have a subpage with a form, David, can you speak about what needs to be in place for people on the call to ensure that if somebody is filling out the form, you have a shot at getting express consent, and then at the very least you're at least getting implied consent.
Right. Okay. So implied consent is by virtue of a relationship. So the only consent you're actually seeking is express consent. So doing that right, it's a bit of an art and it's a bit of a science. First, the technical stuff, similar to sending a CEM. If you getting express consent, whether it's on a web page or a piece of paper, it doesn't really matter. But you have to disclose the same stuff: your identity, address, at least one of web address, phone number, email address. You have to have the statement that says that you can unsubscribe and change at any time. And you have to describe what the person is consenting to. You have to let people know what they're signing up for. And if you're doing the managed subscription thing, that works really well because you're saying, okay, I'm accepting A and B, but I'm not accepting C or D. Or even if it's just a broad statement that says, promotional email about our products, whatever, that's fine. So you have to have all of that stuff there. Now, from the issue that we've been talking about, knowing that it's really me that's on that page, that's where you want to, and not some spammer who's using it to try and do something different, or not me trying to play a joke on my friend. That's where you see people setting up to say, I fill that form out, and then it sends an email back to me and says, okay, David, you just did this. If it really was you, click here, and then it goes back and finishes it off. So that authenticates me, so it lessens the chance that there's a problem. The art to it is trying to set that up and the text up in a compelling way to get people to actually do what you want them to do. So you have to make it dead simple, and you have to make it make the person want to do it. You have to make them think that they're going to miss something if they don't. So there's a real marketing art around how you do that. And you may want to, for example, put the consent button high up at the top of the page as opposed to the bottom, so they don't have to scroll through it. And you might want to make sure that the language that describes what you're consenting to is very clear but very short, and the page has to present well. So there's a whole bunch of stuff that has to go there. And people were saying when people were getting consents pre-July 1, there was a huge difference in uptake from one to others. Some of them were getting like single-digit percentages that were saying yes. Some were getting significant percentages, like 50% in a day, stuff like that. It depended on a number of things. It depended, A, how clean your list was in the first place, like how many people you had on your list that really didn't care. But part of it was how well you set that up. If you set it up so it was A, dead simple for the person to go, boom, yes, I want that, as opposed to having to go through hoops, and they might go, whatever, I'll do that later, and never get to it. Or for making it just easy, top of the page, compelling, convincing, hey, I can't afford not to get this stuff. So there's a number of factors went into the success rate of those pre-July 1 attempts.
Okay, so on a sub-page with a form, you need to disclose your identity. You need to have an appropriate consent message.
Yes.
Make it compelling, from a marketing perspective. To tell them what you're going to do with the information. So be clear. Tell them that they may unsubscribe at any time. So that's so disclose identity, consent message, and then they need to. And this is a kind of a trickier one. They need to not necessarily check a box, but that can happen. But they need to take some kind of affirmative action. Can you speak about that a little bit more, David?
Yeah. Between the Act and the interpretations and positions of the CRTC that's enforcing this, they've put out papers that said that you can't do what they would call toggling. So you can't pre-check the box yes, so the default can't be yes. So basically you do have to take a positive act. So that positive act could be ticking a box that says, yes, I want to do this, or it could be if you have to fill out your email address manually, it can be simply, it can be saying, by entering my email address here, I consent to. So it depends. If you've already got the person's email address for some reason is pre-populated, you don't want to necessarily have them type their email address in again. But as long as there's a clear button that says, I consent, or whatever. But it has to be some positive act. It has to be opt-in. It can't be opt-out. I think that's a problem. There's a fundamental flaw in their reasoning on it, but the fact is that's the way they're interpreting it.
Yeah, so everybody probably saw that in the old days. You probably used to see a lot of the times where the checkbox was pre-checked. And now what David is saying, that if you go that route of providing a checkbox, regulators are saying, no, you can't go with the checkbox on and force them to check it off, known as opt-out. They need to check. They need to affirmatively check that box on if you do the checkbox method.
Yeah, that's right. Under the privacy laws, you can get away with opt-out in certain circumstances, not all circumstances, but some. But for the purposes of CASL, the CRTC is not interpreting it that way.
When you say privacy laws, there's PIPEDA. Is there any other ones that are relevant?
Yeah, PIPEDA is the main one. That's the federal privacy legislation that governs commerce in general in Canada. People who are in some other provinces have their own, like Alberta and BC, Quebec, Nova Scotia maybe. I think there's a very few of them. They have their own legislation that replaces PIPEDA in those provinces. But but for the most part, yeah, that's those privacy laws still apply the same way that they always did. And in fact, this legislation added a provision to PIPEDA, basically making it illegal to electronically harvest email addresses off of websites. So you can go to a website and get somebody's email address and use that, but you can't use a bot to go collect email addresses off of websites.
Okay, and I'm gonna go there in a couple minutes on that kind of vein, because I think that's going to open up some questions too. Before we go there, though, you and I spoke in the past, and you mentioned something that I just want to explore. You had mentioned that you, as a business, you can't force someone to provide consent as a means of providing them goods and services. Can you explain that a little bit more?
Yeah, basically what you can't do is say, okay, the only way you can buy my widget is if you consent to sharing your information with a third party, or if you consent to getting my CEM. So you can't, because that's not it's not a free consent. It may be informed, but it's not voluntary. So you can't tie the permissions for either a privacy permission or a CASL consent to say that by buying my product, I'm going to deem you to have given express consent. You can't do that.
Mm-hmm. What part of the Act is that under, or which regulation?
That is, I don't believe that's actually stated in the Act. I think that's more or less the interpretation that is being put on it, and it makes sense given the kind of the total flow of the Act that would be how the CRTC or a court would interpret that, because otherwise it's not really consent.
Mm-hmm. Mm-hmm.
Now, having said that, there are some people that have gotten creative on consent. When they sent these emails out asking for consent, they were saying, if you consent, we'll put your name into a draw for this or draw for that or something like that. And I don't see that. In fact, there was a bunch of us dealing with this. We're sitting around the table a while back in a conference. We're talking about this situation, and we kind of all thought, okay, yeah, that, as long as you're meeting all the normal contest rules and legalities around that there's nothing wrong with that, because people don't have to enter your contest. So that's perfectly fine. So we saw a few of those. Disappointed that I didn't win the webcam that I signed up for, but that's the way it goes.
So someone on the call is at a trade show, or let's say their sales team's at a trade show, and or a networking event. You know, it's kind of the same context. They receive a business card from somebody at this trade show. What are the rules? This is a person in a sales role who will be, you know, sending a CEM to that person. That's their intention. What are the rules to receive that business?
Well, there is an exception in the Act that people are calling the business card exception. Now, the Act never uses the term business card, but it basically, this is in section, just look for the section number here. It is in section 10 of the Act, and 10 sub 8 actually. No, 10 sub 9. If I'm at a network event and I meet Andrew for the first time, if Andrew hands me a business card, and Andrew doesn't say when he hands me that business card, hey, don't spam me, then I have implied consent to send CEM to Andrew so long as the message is relevant to his business role, function, or duties in his business capacity. So given if I was a travel agent, that probably wouldn't allow me to send Andrew a CEM trying to sell him a timeshare in Florida, because that's not relevant to Andrew's business role or functions. But we're not sure what the breadth of that is. But if I want to send him an email that is, you know, remotely relevant to his business or what he does in his business, then I can do that. Now, there's another exception that ties into that that's similar, and that's if the person has published their email address themselves. So if they publish it on their own website, for example, the same thing applies. Same caveat, it has to be relevant to their role. So, you know, for someone like myself who has my profile up on the Harrison Pencil website, I've got it up in my blog, but there's all kinds of places where I publish my email address. That exception applies to anyone who wants to send me a CEM, but only if it's relevant to my sort of role as a lawyer. So again, someone trying to sell me the timeshare or the Caribbean cruise can't take advantage of that. But if they're trying to sell me something that's somehow relevant to my practice of law, then that's okay. Now, the tough part about that is that you have to be able to prove that. If Andrew comes back and says, "Wait a minute, David spammed me. I never gave him consent," the onus is on me to prove that. So that can get kind of tough. But that's kind of the way it worked. And just to point out something, there's a lot of weird stuff about this act. But these implied consents don't have a time frame on them. So, so you have potentially a longer period of time for that than some of the implied relationships from people who have actually done business with you, which is really bizarre, but what it is.
In this business card rule, if you want to call it that, when sending someone that has given you a business card at an event, and you've made the sending them an email to someone who had given you a business card at an event, and you make the email consistent with their role or function, do you need to follow some of the other requirements within a CEM? I guess,
yes.
A is it deemed a CEM under the legislation, and regardless of the answer to that, you have to provide identity and you have to provide an unsubscribe mechanism.
Yeah, there's two-part answer to that. If it is a CEM, any of these implied consents do require you to have all those formalities in there. So if you hand me your business card, I'm still technically supposed to put all that stuff in there. Yeah, so that has to be, that clearly has to be there. The other thing, though, that's not clear where the line is whether or not it's a CEM. So, and it's a bit unclear what the threshold is. And the definition itself is broad enough to say that a mere link in my email footer to my web page is enough to turn even an innocuous, hey, what's the weather like where you are today, Andrew, into a CEM. But the CRTC has actually said that, well, that doesn't make a lot of sense. So just because someone has a link in their footer to their home page doesn't turn into a CEM. But if that link goes to a hard sell special page, then it might be a different story. So it's kind of weird in that if I'm relying on this exception, well, I don't even get to this exception because it's not a CEM. If I meet Andrew at a networking event for the first time, when I send Andrew an email and say, it was nice to meet you at the X event yesterday, would you like to get together for lunch someday? That's not a CEM. But if I say, and maybe we can discuss what services I could provide for you, then it's a CEM and you're caught. So it's really quite bizarre. The threshold, it doesn't take much to get over that threshold.
And in that scenario, you sending me the email, if I gave you my business card, you would have implied consent with no timeline. You must identify yourself when sending it, that CEM. You must provide an unsubscribe mechanism,
Yep.
but no timeline unless to purge unless I unsubscribe.
Basically, yeah, that's right.
Okay. Can we then move over to the topic of if a business on the call is ever audited, like that whole process of, you know, where does the onus fall on evidencing this consent, and you have some tips around record keeping for organizations on the call.
Right. Well, clearly the onus on proving consent is on the person who sent the email. So from a practical perspective, that means that we're all somehow have to keep some records of who we have consent from and who we don't have consent from, in case, so if, you know, the CRTC ever comes knocking, or if you know, someone complains to them, or if down the road when the private rights of action kicks in, someone sues you, you have to prove that, yes, I did have permission to send that, or else you're in trouble. And so whether that's express consent or implied consent, you somehow have to prove that it's, let's say, relying on the business relationship, existing business relationship rule. If you can prove that they work for a company that they bought something to you within the last 2 years, if you can prove that, you're okay. If you can prove that it's a B2B thing and you can prove there's a relationship, you're okay. But you somehow need to be able to prove that. And these ones about getting business cards and getting the emails off of websites is a bit troubling, because I'm not sure how you would ever prove where you got that. But the best you could do is somehow make a note or an entry into a, you know, if you, assuming you have a system to do that, somehow make a note that says, okay, I got Andrew's email. I sent Andrew an email this date, and I got his address from his website, and keep that record somehow. And the same thing on a business card. Now, what's your risk on that? The risk is, because you're sending it to one person, the risk is that that person would complain. But if you do it a lot, people can sort of get together and complain. You know, I suppose if you really wanted to go crazy on a business card, you could say, hand the business card back to Andrew and say, okay, please write on the back of this, you can email me, date it, and sign it, right? And then keep that if you really, but who's going to do that at a networking event, right? But yeah, theoretically you have to keep track of all that stuff, because it's the only way you can prove, if push comes to the shove, that you didn't violate the act.
Okay. there is going to be some people on the call who sit on, or rather serve on, board of director boards within organizations. And you had mentioned to me in the past, offline, David, that there is some liability for officers and directors within an organization if their organization is violating CASL. Can you explain that a little bit better and provide any tips, if you have any, on how a board member who may be on a call right now can protect themselves?
Right. The Act has a provision in there that says directors and officers can be personally liable under the Act. In other words, same penalties, fines, etc., that their employer, if you're an officer, or the company that you're a board member on has, if you participate or acquiesce in the offense. So basically what a director needs to do, or directors and officers need to do to prevent that personal liability, is they have to make sure that the business has done its homework on CASL and is at least trying to abide by it. So, you might put in a policy at the board level that says, we're aware of this legislation, and you can't spam, and all this kind of stuff. You want to make sure that there's some processes in place, some training in place, something in place that's sufficient that you as a director can, if something goes wrong, you can say, well, we tried, we did what we could. Maybe something got through, but I didn't take part in it because I didn't send it or have anything to do. I didn't mandate. I didn't say to the salespeople, you got to send this email out, and I didn't acquiesce in it in the sense that we tried to put processes in place to prevent it. We aren't just thumbing our nose at this legislation. So that's what directors and officers kind of need to do to protect themselves.
Okay, it does. So if you're a director or an officer, you may want to be thinking about that and taking some action, bringing it up with your board or executives within the organization, and ensuring, as David said, that proper awareness, processes, and training has been conducted within that organization, so that that company has the best shot that it can at complying with this legislation.
Right, and that not only protects the directors and officers, but it goes to, if there is a violation, it helps go to reduce the impact of the sanction that's going to be levied, because it's one thing to say, to ignore it completely, just go willy-nilly and do what you want. It's another thing that if someone makes a mistake, in spite of the fact that you've tried and you've got the right education and policies and stuff in place. And another thing that directors should check, and I don't know the answer to this one, but lots of directors and officers liability policies often, and maybe almost always, they don't reimburse for criminal, quasi-criminal actions. And I don't know, it's something that everybody should ask their D&O insurers at some point, is whether or not D&O insurance would actually cover, for directors, would actually cover a CASL penalty or not. So directors, they should be asking that at the very least when their D&O policy rolls over. They should be asking that question.
Great piece of advice, David, for anybody who is a director of a corporation. Find out if A, the company has insurance, and B, if it is covering CASL. Okay, so at this point in time, I'm going to move over to questions now from our audience members, and we have a whole bunch of questions. I want to really get to what is on some of your minds and look at some of your situations here. So Jeff asks, we have a membership base, and so Jeff his background is retail. We have a membership base. Our customers pay an annual fee, and for that they get a special discount for their purchases. In addition, they receive emails from us highlighting our specials. Is the paying of the membership and receiving these messages in the past mean we have implied consent? And can we continue to email them?
Well, I think I have to be careful here about giving specific legal advice in a webinar. I can't kind of go down that road, but let me just look at something here. It would make sense in the abstract that, and you have to be careful because the Act does talk about membership, but when it talks about membership, it means membership in like a charitable, unincorporated association type sense, not that type of sense.
Yeah.
But you know, it talks about if a written contract is in place and not expired. It talks about the purchase of a product, good, service. So again, arguably, if somebody's paying an ongoing fee for something, that they're an existing. That means that they're an existing customer. So yeah, I would say that should probably make sense.
Mm-hmm. And assuming that that Jeff's company sent a CEM pre-July 1, that's when the transitional period would kick in, and then 2 years from the last transaction after July 1, if they're a customer after July 1.
Yeah, if the facts line up, that would be the kind of situation where if they've been sending commercial electronic messages before July 1st, that transition period may very well apply. So you'd have to take a close look at the facts compared to the legislation to make sure, but that is the type of situation that it could possibly apply to. Yeah.
Yeah, and to follow, David's disclaimer, because we're getting into very specific business situations, we're only looking at 3 or 4 lines of text. So David's going to probably be missing some context here. So please take this information not as legal advice. Consult a lawyer so that someone like David, you can reach out to David for legal advice. That way, someone like David can get a fuller breadth of a scenario and then be able to provide legal counsel within this scenario. But we'll keep diving into these questions, though, and we'll do our best to answer them for you. Jillian asks, would an email inviting guests a free value-added service, like an educational webinar, for example, qualify as a CEM? And she's making clear no dollars are being exchanged. So yeah, that's quote unquote.
That's one of those it depends things. I'll give you an example. There was a webinar that I was on the receiving end, not on the giving end, several months ago, that the CRTC was talking about this legislation. And it was a webinar to lawyers, and the question was asked to the CRTC, if a lawyer sends out a emailed newsletter, is that a CEM? The answer that the CRTC gave to that was that if that newsletter merely says, here's a new piece of legislation that came out, here's kind of what it says, here's what you should be aware of, or the Supreme Court of Canada decided this case last week and kind of here's what the case said, it's not a CEM. The minute you add a line that says, we can help you with this, or David practices in this area, it turns it into a CEM. So it doesn't take much, and you have to be really, really careful when you're doing this newsletter stuff and webinar stuff as to does it cross that line or not? And it's not always going to be easy to figure out where that line is, right? Because by nature, you're trying to sell something, but yeah, it's not clear at this point where that line is.
I have kind of an odd question that just came out, my brain as a result of your answer. The webinar that we're hosting right now, I gave a shout out. I said, you can if you need legal services, go to David. He's an expert on this topic. So that certainly is commercial in nature. Yep. Is the webinar itself a CEM?
Well, no, because it's we're broadcasting this thing out, right? So the email that you send to promote it is, but the broadcast itself isn't.
If I say though in that email, we can help you with those services.
Yeah,
that's getting right because that's getting back to Jillian's, isn't it?
Yeah, you're exactly right. And quite frankly, I don't remember exactly what your promotional email about this said, but okay. Yeah, if it talks in any way, shape, or form suggests that either TBK can provide certain services or that I can provide certain services, then yes, it is definitely a CEM.
But the webinar itself, what we're in right now, is not a CEM.
No, it's not.
Okay. I was looking at message because we definitely are sending messages right now, and they are electronic. Okay. And so to summarize Jillian's, the answer there, David, you think she can probably get away with it if it really is not commercial in nature, right? That correspondence?
Yeah, you have to be really careful to keep it at a high level and not introduce anything that's vaguely promotional in that whatsoever.
Okay.
And even if her email footer had a link to links to her homepage, she's probably okay. But if it links to a hard sales page for a product, then that could be enough to make it a CEM.
Mm-hmm. Susan asks, our company executes few email marketing campaigns and spends more time on one-to-one business development. What is the best way to approach this sales strategy? David, if I may, I'm going to take a crack at answering that one for Susan, because we've been in this position within our company too, where we're trying to figure all this stuff out. I think Susan, certainly training your individual sales team members on Castle is going to be very important, because some kind of conclusion is going to have to be made on how you really treat your CEMs when they're going out, and you may as a company decide that you're going to leave it up to their judgment, or you're going to do these kind of right across the board types of decisions. So I think training is going to happen. And then based on that kind of knowledge base that you develop, you're going to have to develop probably some processes, because if one person does have a CEM and that person does get an unsubscribe as a result of sending that CEM, some kind of set of actions need to happen within your organization to acknowledge that, so that the next salesperson who is in that role isn't sending that person a CEM, because I assume you may have a CRM that's managing all of this client database, and you may have different salespeople come and go over the years. So I think training is going to be important, and then process based on that knowledge base. David, was there anything else to add to that?
No, the only thing I would add is that the overall approach I think businesses should take to this, if you don't know where to start, is sit down and do sort of your own sort of audit, as it were, of your electronic communication practices. So figure out, okay, what kind of emails do people in our company send? Who do they send them to? Do different people send them in different ways? So, is there, for example, a segment, a sales force that's sending this stuff, but most of the other people don't? Do we have, who are we sending these to? Are they existing businesses? Are they cold emails to new people? Are they, how do they fit in with this whole thing? And once you get a picture of that, of what you send, who you send them to, who sends them and why, then it becomes a little easier to kind of start saying, okay, from a Castle perspective, which stuff here is CEM, which isn't, and what stuff just can't we send? How are we going to deal with this unsubscribe? Should we just put an automatic footer on everybody's email to deal with it, and all those other things? So every situation is going to be different. I've had some clients where they do very little that Castle impacts them on, and it's fairly easy for them to comply. And I've had others that have had to spend huge amounts of time figuring out how to handle it, what applies, what doesn't, how they can sort of change their practices a little bit to try and fit and all that sort of thing. So it's really dependent on the nature of the business.
Great answer. David, Diane asks something that's going to be relevant to most of the businesses on the call. What about sending invoices? And to expand on that a little bit, what Diane is probably thinking about is, what if, for instance, somebody has previously unsubscribed, but you still need to get, payment from them. You're sending them an invoice. Or what if you're doing invoice follow-up? There's, processes for within your finance department.
No, well, first of all, if you're sending them by mail, it doesn't matter. If you're emailing, sending someone an invoice saying, thank you for your patronage. Here's your bill for the services we've rendered. That's certainly not a CEM. And sending follow-ups to collect that certainly is not a CEM. In fact, there are specific exceptions in the Act for things that are sent to enforce a legal right, like that kind of stuff. So in addition to it not being CEM, it's expressly states it's not a CEM. Now, if you're going to, I suppose, if you're going to send an email, an invoice out, and put a whole bunch of promotional stuff on that email, that would be definitely deemed to be a CEM. So it's probably not a good idea to do a lot on that, or a lot of promotional stuff in your invoices.
Right. So when sending out that invoice, assuming you're not putting a whole bunch of promotional or any promotional material in the signature, for instance, does that business need to provide an unsubscribe function, proper identity, or are they exempt from that?
No, they're exempt from that because it's not a CEM. That would be great if we could unsubscribe from getting invoices, but it's not going to work.
I'm just going through some questions here. We only have a couple more minutes, and then we should complete the call here. I hope this has been answering a lot of your questions that you had coming onto the call. Okay. Erica asks, did I understand correctly that getting a person's business card from them constitutes implied consent, but yet it's not subject to the 2-year timeline expiry?
Yes, that's right. It's odd, but that's right.
You heard it right, Erica. Okay. So I want to wrap up the call for everybody. I would love to hear, definitely send me an email letting me know how the webinar was for you, and if we were able to really answer a lot of your burning questions around Castle, because David and I really came onto the call really wanting to help your organizations better operate within Castle and improve your performance while complying with the rules. Some of those things that we kind of set out to do at the start of the call. So let me know if we accomplish that task. And David, if anybody wants to get in touch with you for services or just to reach out, how can they do that?
Yeah, first of all, if you want to know more about CASL in general, the CRTC's website has a lot of stuff on it. At harrisonpensa.com, we have a page dedicated to it. And on my blog, which is elegal.ca, I've written quite a bit about that, including a 5-part article series a little over a year ago. But if you need some specific advice on that, people can certainly email me or call me or whatever. And sending me an email, line of time, well, this is not a CEM. Mm-hmm. So that's not a problem. So it's dcanton@harrisonpensa.com.
Okay. David, thank you for taking the time and sharing your knowledge on the call with everybody here today.
You're welcome, Andrew.